versus Casey Michael McKenzie, file number 23-21324FH. Salvatore Malaro appearing on behalf of the defendant, and I have Dave McCready appearing on behalf of the prosecutor's office. This is the date and time. I just have the probation. No, this makes sense. Why is this just a violation of probation today?
Yeah, Judge, I just noticed that myself. We had prelim back in April that got bound upstairs. The transcripts probably due next week, I think, like middle of July, at which point we would be looking at motions to file.
So why don't we move this over to the September 4 date? Because that, if you get transcripts mid-July, that gives you 6 weeks to do your motions.
Well, I think Mr. McKenzie wants things to move a little faster. Is that correct?
Yeah, very.
Well, it takes
trial in 180 days. I even have a prelim for 90 some days.
Okay. So you're waiting on your transcripts, correct?
Yeah.
So they come when they come. They have a time period that they're allowed to get those done by, and they're not going to be done till July. And so you really, your attorneys probably advised you that you don't want to proceed to get those transcripts.
So in order to file a motion for my prelim being pushed back 3 separate times due to the prosecutor filing bad writs or however, I just would.
I can't argue the merits of that today because I got to wait for motions, and your attorney will file the motions.
So that means I can't have a trial in 80 days. That's correct.
Do you want me to set you for trial now?
Yes.
Your Honor.
Without your, yes, Ms. Teskey.
This is a whole separate probation violation from his new crimes. Like, this is a probation violation for him being terminated from treatment. It has nothing to do with his new crimes.
So the only thing we're here for today is your probation violation. If you want to plead to your probation violation, I'll be more than happy to sentence you on that. On your probation violation, you're actually facing up to, let's see. So in your probation violation, it alleges that you absconded from the Eaton County RAP program. And that requires, is that right, Ms. Teskey?
No,
All right, guys, buckle up because this video kicks off with exactly what you've been asking for. We're promised strict judges, stubborn defendants, and zero patience for courtroom nonsense. Right away, the tone is set. This isn't going to be soft, slow, or forgiving. The intro frames the frustration, tees up the conflict, and lets you know this is about accountability colliding head-on with arrogance. You can already feel that someone is about to talk themselves into serious trouble.
On the violation of probation, your violation of probation has nothing to do with your new charges. So if you want to plead to your violation of probation from being terminated for getting into a dispute with another inmate in the program, I'd be more than happy to take your plea, but understand you automatically have to go to prison on this.
Judge, when I spoke to Mr. McKenzie about that, he indicated he wanted to separate here.
Wants to separate. All right, I can set you a trial on this. Yeah. So Ms. Teskey, how long do you need for a trial to get your witnesses from Eaton County on this?
Your Honor, I would say 2 weeks.
2 weeks. All right, Miss Adams, I need probably an hour for a violation of probation trial.
And Your Honor, for the record, I'm sure Mr. McKenzie would oppose any testimony by Zoom.
Oh.
Is that correct, Mr. McKenzie? Yes.
Okay.
Can he do that, Your Honor?
Yep. So, I mean, yeah, it's just someone that works there. That's all you need is someone that works there, right? So, all right. So, Ms. Adams, I'm looking for about an hour.
Yeah.
Who are you going to call as?
I'll bring the book in, Judge. I'm not finding an hour.
Okay. And Mr. Malaro, your client would testify potentially. And then who else will you be calling as a witness?
And discuss that with him. Do you have some witnesses?
Yeah, her name's Tamia Dillard.
Tamia Dillard. Oh, she runs the program.
Yeah.
Tamia?
Yeah.
Tamia Dillard, was he there?
No, she's a lady that runs it. They never took a statement or nothing from me.
Well, they don't have to. They don't have to.
Well, Judge, I've spoken to her in the past. I think she runs the program.
All
She
right,
does,
so,
and she was who I would be calling for a witness as well.
okay, so.
Are you definitely gonna call her, Ms. Teskey?
Yes,
So I would not have to subpoena her
no,
then? All right, you okay with that?
Yeah.
All right.
Ms. Antoine, could I speak for a second?
No, I'm looking for a date, so you gotta wait a minute.
Oh, yeah. What the fuck is that?
I'm sorry, what'd you say?
I told him I know what to say. He can't be my lawyer. I can't do this with him.
Then you are more than welcome to hire an attorney, but,
I need somebody that's gonna do something.
so, Mr. McKenzie, here's the deal. You ask for court-appointed attorney, you get a court-appointed
I got
attorney.
this back
Listen
off.
to me.
Now
All
listen.
right, you are held in contempt,
Oh my
so
God, you think
I'll bring you
I-
back next week. Thank you.
Give me 2 years of contempt, please. Could you?
You're actually looking at 5 years.
Oh, please don't.
Oh,
Fucking
have a good
ugly fat
day.
bitch.
oh, like that's the worst thing I've ever been called.
All right, guys. Now we're officially in the courtroom, and the tension starts building fast. Mackenzie immediately tries to rush the process, pushing for speed without understanding how badly that can backfire. The judge calmly explains procedure, deadlines, and reality, while the defendant keeps pushing. This is where you see the classic mistake, confusing impatience with leverage. Every word he says digs him a little deeper, and the judge is clearly taking notes.
Yes,
Those sunglasses, or are they prescription?
prescription.
Do you see the plea questionnaire waiver of rights form I have in front of me?
I see on this,
Did your attorney go over this document with you?
very briefly.
Well, maybe if you weren't 18 minutes late, you could add more time with your attorney, right?
I forgot my money. I had to turn around.
Maybe you should have been here maybe 20 minutes prior to your hearing to go over this with your attorney, correct?
Correct.
And I do have a copy of it in front of them as well.
Thank you. And the fact that you forgot the money, is it the court's problem?
A little bit, I mean, but.
Oh, I
it's-
forgot it
it's-
for you?
No, it's my problem, but it made it your problem.
It did make it
By
my problem. It made
postponing-
it the district
by
attorney's problem. It made it Mr.
postponing-
Keene's problem.
I apologize.
You are putting my calendar behind right away in the morning.
That's what why I said it is a little bit your problem.
No, it is my problem
Yeah.
because you made it my
Yeah,
problem.
yes, yes.
So he went over this document with you, correct?
I have to do stuff and I have a copy.
Yeah, yep. So he's went over multiple times. You've had Mr. Keene for some time on this case, correct?
Mhm.
Yes?
Yes,
And you've had him for this time when you've been trying to complete the IDIP, correct?
and I have.
Okay, and so Mr. Keene, this isn't the first time he's talked to you about what it means to plead guilty to an OWI third, correct?
Correct.
And he's went over with you what the state would have to prove, correct?
Yeah.
Correct?
Correct.
And he's went over the maximum penalties and the minimum penalties you could face. Is that correct?
Yeah,
And he's went over the offer with you that has been presented by Mr. Renicky to recommend to the court IDIP guidelines, correct? What the
Yeah.
offer is, correct? Because you know you're doing an IDIP program for benefits, right?
There was a little confusion between my IDIP worker and him about the hours for community
I
service.
don't care about the community
Okay,
service
okay,
hours,
I'm just saying that
the other stuff, right?
the other stuff, yes.
Okay. And so he's went over certain other things with you, right? Such as your constitutional rights. Did he go over that with you?
Yes,
And did he go over the fact that I don't have to accept the IDIP guidelines if I thought that the facts of the case warranted it, or your history, et cetera? Did he go over that with you?
yes, ma'am.
Okay, so it sounds like he did go over all of the information on this plea questionnaire. Is that your signature on the second page?
Yes.
So you are 44 years old. You can read, write, you understand the English language. You have not had any drugs, alcohol, or other medications, and you have not been deemed mentally incompetent, correct?
Correct.
So do you understand all of those constitutional rights on that document that's sitting there right in front of you?
Yes, Your Honor.
Do you need me to go over those rights with you in any more detail?
No, Your Honor.
You understand that by pleading guilty, you're waiving and giving up those rights? You won't be able to have those rights again. You can't plead guilty and say, you know what, judge, I changed my mind. I want a jury trial. You know, do you understand that?
Yes.
And so by pleading guilty, those rights are going away. You understand that?
Yes.
Okay. Now, do you understand that if you're not a citizen of the United States, your plea could result in your deportation? I don't allow coffee in here.
I'm sorry.
I only allow water.
Apologize.
Okay. So do you understand that by pleading guilty, you could be deported if you're not a citizen? I have to ask that
Yes,
to everybody. Okay. And do you understand that, again, here, the state would have to prove certain things that on or around May 28th, 2023, in Burnett County, Wisconsin, you operated a motor vehicle while under the influence of an intoxicant. And this would be a third offense. Do you understand what the state would have to prove?
What would they have to prove?
You operated a motor vehicle,
Okay,
you
yeah,
drove, you operated, you
Yeah.
turned a key, you had the keys
Okay.
in the ignition, you did something to operate the motor vehicle.
Okay.
And that you were under the influence of an intoxicant. You understand that?
Okay.
Okay. Do you understand they would have to prove that?
Mhm.
Okay. And this is your third offense, third conviction? Right? Is that a yes?
Yes.
Okay. And do you understand that upon conviction, you face a fine of not more than $2,000, that excludes court costs and fees, and imprisonment of not less than 45 days, but no more than 1 year in the county jail. Do you understand that?
Yes.
Plus that the court shall revoke your operating privileges for not less than 2 years, but no more than 3 years, and shall order you to submit to an AODA OWI assessment and driver safety plan and follow through. You understand that? Yes?
Yes.
And you should have done that with the IDIP program, so that should be
It's taken
covered.
care of.
yes. All right. Now, again, you understand that I'm not bound to follow any recommendation, and that would include following the IDIP guidelines.
Yes.
I could sentence you all the way up to the maximum possible penalty, again, if I thought it was warranted. You understand that?
Yes.
Do you have any questions for your attorney or the court before we proceed?
All right.
And there's all kinds of fun today.
Damn it.
All right, guys, this is the moment where the consequences become crystal clear. The judge explains that this isn't about new charges at all. It's about a probation violation that carries automatic prison time. There's no debate, no loophole, and no clever argument to escape it. The program he failed was his second chance, and failing it erased all leniency. You can almost hear the door closing as the judge lays it out, piece by piece.
Okay.
Sorry about that.
All right. So you understand I could sentence you to the maximum penalty?
Yes.
Okay. Any questions?
Just one.
There's a question right now going through the plea, or is that a question later for sentencing?
It's just kind of a math question. I just want to know if it's fictional or a fact.
Math is usually not fiction. Why,
Yeah.
it's math.
And yeah, so I'd just like to be explained, like, how the math works. So I'm pretty good at math.
Want me to get a math professor in here to explain it? Because I'm not a mathematician.
That's what he said.
That he's not a mathematician because he's not, because quite honest, we go to law school, so we don't have to do math, but we have to do math in our job. What's your question?
Just to know if this is fictional or factual.
I don't know what this is.
Would you like me to?
No, what is this, Mr. Keene?
Yeah, I think it's great. The issue, and it's been up, I'm with, Ms. Anderson, is he had a question about the, grams per 100 milliliters.
Dude,
And
that's a scientific question. You can call up the scientists or the lab analysts that do that. I'm not in charge of that. And the legislature makes up the laws. I'm in charge of following and enforcing the laws.
Okay.
So what's your question? You think that you were below the limit, above the limit, beyond the limit, how they came up with the limit?
According to this, I was not above the
Oh,
limit.
Okay, and that's like a AI chatbot thing, right?
Yeah. so
Yeah,
Maybe it's wrong. I don't know.
yeah, it is.
An AI chatbot?
But
Are we using artificial intelligence?
it's just that I was measured in thousands, and the law goes by hundreds.
We can have a trial if you want.
I am so great to have a trial. I love having trials, especially when the lab analyst comes, and especially when then it completely opens up to the maximum penalties. That's great and fine with me. Is that what you wish to do, and have a lab analyst up here to explain all of the scientific reasoning behind the calculations and behind their testing?
Just
All right, guys, this is where everything collapses. Mackenzie starts arguing, interrupting, and openly disrespecting the court, all while claiming he needs help. The judge stays composed but firm, making it clear that court-appointed counsel is not optional entertainment. Every outburst tightens the situation until the judge finally draws the line. Contempt is declared, and just like that, talking turned into time.
Saying he's not rushing to press the point, Your Honor.
All right. Okay. So now, did you review the criminal complaint with your attorney? And it has all of those facts that says what happened that day from the officer's perspective and from your perspective, because you said, I only had 1 or 2 beers, which we know isn't factually true.
no, I had 0. I had drinking the night before.
So then you drank a lot more than 1 or 2 beers the night before.
I had a six pack of 16 ounces and a 16 ounce.
And yet you blew a .221 allegedly in the criminal complaint.
Yeah, and that's what I'm saying is that 221 is thousands, not hundreds.
Oh, Mr. Lamprecht, Mr. Lamprecht. It's .08 in Wisconsin to be legally drunk. And for 1 or 2 beers or a 6-pack or whatever you said the night before, unless you are a chronic alcoholic who drinks all the time, you won't wake up the next morning to blow a .221. It's impossible.
Exactly.
But you did. And we have lab, right, Mr. Renicky?
We have a lab.
What does lab say? Where they tested it with scientific stuff.
I didn't mean to put you in a bad mood.
0.19. You did by starting by being late.
I
Okay,
apologize.
you're not supposed to be late to court. Okay, you're supposed to be here early so you can meet with your attorney. And quite honestly, and it's taken you months and 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 months to do the IDIP program. I gave you yet another chance, and now you're here debating.
No, I'm just
Science.
saying, anytime you put a numeral behind the decimal, like 1 numeral behind the decimal is a 10th, 2 numerals behind the decimal is 100th.
Yep.
3 numerals behind the decimal is 1,000th.
Yep, I know math.
Okay, and
All right, guys, new courtroom, same energy, but somehow even worse. This defendant starts his hearing late and immediately blames for getting money, as if that explains everything. The judge isn't buying it for a second. You can feel the irritation build as excuses stack up, because this court expects responsibility, not casual apologies. From the very first exchange, it's clear this defendant is already behind and about to make it worse.
Well, let's cut that off, okay? You blew a .22 with a PBT.
221.
Or .221, okay? So let's say you will cut off the 1, because that's what math does. You get to cut off certain things. So you were .22. We'll give you the benefit of the doubt. No more with that 1, that 1,000th, gone. So you blew a .22. But lab came back and said, guess what? We ran his blood, which is more accurate. And it gave us a better truth of what happened. And it was 0.19. It's 0.08 in Wisconsin to be legally intoxicated and operate. So you get it now? You understand now?
I don't understand how 1,000 is 100.
I cut it off. I agree with, I'll give you the benefit. I cut that off. It's 0.22. It's 0.22.
But no, if there's three numerals,
Yeah, I think
because if it was point,
Mr.
If
Renicky,
it was-
I'd love to have a jury trial because it sounds like he doesn't understand the science and he wants to have a lab analyst here. Is that right, Mr. Keen? Is that what I'm hearing? He wants to have a jury trial because we can facilitate that next week.
I'm just saying what math.
I had a
is.
jury trial come up, not next week, the week after. We can get a jury trial. Is that what you want? You want to fight that issue of this extra thousandth in the decimal point?
It's not an extra 1,000 though. It's 1,000th or it's not.
Okay, it's 1,000th or it's not.
Yeah.
Is, you want to go to trial over that and have the lab analyst explain it? Because I'm going to tell you, she is far smarter than I am when it comes to science and to explain it to you. Then maybe you'll be able to understand. You won't be able to
Okay,
ask your questions.
How about this? Can I just go to jail and I'll give you this copy?
I don't need the copy.
Okay, and then just, so give me the knowledge because I like math.
Clearly, math doesn't like you.
Here's what you
1,000
can do to gain knowledge. Call up a lab analyst, have them explain it to you.
just
Because
take
that's
me-
what happens
just
in a jury trial. And I hear it. It goes on for hours.
not
We have
trying to-
hours.
Piss you off. Just take me to jail. I'm fine with that. I have the money finally at the last moment. You've been very giving, lenient with me and giving extensions. You're fair. And I'm here. And I'll go to jail, get out. I got a job and
All right.
Fine.
So are you admitting that you at least blew over a 0.08 or at least 0.08, at least blood alcohol content was in your blood at the bare minimum?
I agree that I blew a 0.221 and I agree that my blood alcohol was at 0.190.
Okay, all right.
I agree with those.
And so, and do you agree that you operated or drove a motor vehicle
And
while
I-
in that state?
I agree to that, yes.
All right, Mr. Keen, may the court use the probable cause section of the criminal complaint to find a factual basis?
Yes, Your Honor.
Has anyone made any threats to you, Mr. Lamprecht? Any promises for you to plead guilty to this charge? Has anybody promised you anything? Hey, we're gonna give you $1 million if you plead guilty. Or we're gonna give you some kind of benefit if you plead guilty, other than this offer of guidelines.
The only thing that I've been told was that I can get out, keep my job, keep my place, and keep my things.
Okay, so that's not a promise. Anyone threaten you anything? I'm gonna beat you up. I'm gonna take a gun. I'm gonna take a knife.
None of those.
Anybody threaten to hurt you or anything?
None of those.
Okay. Are you pleading guilty with a full understanding of what you're doing here today?
Yes, I'm pleading guilty to blowing a 0.221 and having a blood alcohol content of 0.190.
All right. And you're pleading guilty voluntarily.
Yes.
Does anyone threat, or are you satisfied with your attorney's services?
All right, guys, this part is where the judge methodically shuts every escape door. Constitutional rights, penalties, consequences, everything is explained slowly and clearly. The defendant confirms understanding again and again, unknowingly locking himself into the plea. This isn't dramatic yelling, it's something more dangerous. Calm, precise legal clarity. By the end of this exchange, there's nowhere left to hide, and the pressure is fully on.
Job and the fact that he's looked to see if you had defenses, because I'm going to tell you, your argument here is crap. I don't say crap in court, it's crap.
I'm not, I'm just trying to conversate. I'm not trying to argue.
This
one-
isn't a conversate
Okay,
time, okay? This
Okay.
isn't a time to conversate.
Okay,
This is a plea and sentencing
okay,
in which you showed up to court 18 minutes late.
okay. I forgot my money. I apologize.
Has your attorney talked to you about the case?
Yes,
And has he looked at everything and discussed with you everything that he's seen in discovery?
except for my one question.
All right, because he's not a scientist. But he said you can figure that out. Talk to a scientist, right?
I don't know any.
Mr. Keen, you said that's not a defense, correct?
Yeah, and yes, and we have discussed that in basic math and other things along with it extensively.
All right, okay. You have any? No. All right, so based on this, the OWI third, count one, how do you wish to plead?
Guilty.
Court will find your plea of guilt is done knowingly, intelligently, and voluntarily. I'm going to find that you understand your constitutional rights and what it means to waive and give up those rights. I'm going to find a factual basis to accept your plea of guilt. Based on that, I will find you guilty of count one. Count two will be merged and dismissed with count one. A judgment of conviction will be entered today. Mr. Lamprecht, anything you want to add or say to the court?
Nothing that I haven't already.
Well, I mean, what are you doing employment wise and stuff that you're trying to help the community?
Yeah, I have a job.
Okay.
He has a job, he has a life, he
Yeah.
is there waiting for him after he's done here today, which is all a positive thing. It's all about rehabilitation. OWIs are very serious. I don't make the law. The legislature makes the law. I don't determine the science. The lab analysts who go to school for years and years and years and years and years, the lab analysts, they learn science and they learn how to read scientific data. So they are the smarter ones in the OWI matters. I know the law, I see the law, I read the law, I enforce the law. I ensure that that the community is protected in certain ways. OWI is again serious. You're putting yourself at risk, you're putting others at risk. The fact that you blew a .221, had blood alcohol content from blood at 0.19 is serious, especially given.
All right, guys, this is peak courtroom chaos. The defendant tries to argue blood alcohol math using AI logic, decimals, and imaginary loopholes. The judge dismantles it with brutal patience, explaining science, law, and reality, like she's talking to a brick wall. Every attempt to sound smart makes him look worse, until even he realizes he's losing badly. When he finally says, "Just take me to jail," it's surrender disguised as frustration.
Will ensure that you have more jail time than what's being sentenced here today. All right?
I like you and you're a fair judge. I'm not trying to piss you
Then
off at all.
stop talking.
Okay.
I need to ensure that the public is going to be protected. And that means to ensure that you've learned a lesson, you're rehabilitating, you've done the IDIP program. That's a positive program. It's taking you more than most to do that program, but you've at least completed the program, which is positive. You're going to have the ability to get your license back or get an occupational prior to the end of your revocation. Your attorney is very correct. The next OWI will be a felony. The one after that is mandatory minimum prison sentences. So it's very important that you figured it out now and that you're not going to engage in this type of behavior before or again. What I will do is I will follow the IDIP guidelines. Despite all of the issues in this case, I'm going to follow the IDIP guidelines. I'm going to assess $1,911 in fines and fees with an additional $10 blood draw fee, 45 days in jail, 24 months of ignition interlock device to be placed on any vehicle you drive. Doesn't mean you need to own that vehicle. If you're going to borrow your mother's vehicle to go down the street to the gas station, it must have the IDIP in it or the interlock in it, or you may not drive the vehicle. 24 months of revocation of driver's license, OWI assessment and driver safety plan, 75 hours of community service. You must report immediately report to jail. And that means that You will have to go sit 48 consecutive hours before you are eligible to be released on monitor. I'm going to tell you, this is where I'm going to be very clear with you, Mr. Lamprecht. I take no excuse. If you are going to be released on monitor, you must prepay at least 30 days in advance. If you are even 1 day late on payment for a 30-day advance, you must.
All right, guys, this is where it all ends. The defendant finally admits the facts. The plea is accepted, and the judge delivers the final lesson. She explains why science matters, why OWI laws exist, and why excuses don't outweigh public safety. It's calm, firm, and final, no theatrics, just accountability. If you enjoyed this breakdown, make sure to like the video, subscribe to the channel, and we'll see you in the next video.